saving money by cutting corners on tenant screening? You're not. One bad tenant in California, just one, will cost you upwards of $15,000 in lost rent, damages, and legal fees. That's 6 months of your time, 6 months of your profit, vanished. You've worked too hard for that. This isn't about finding a tenant, it's about protecting your investment. And it starts long before you even meet an applicant. Your tenant screening process begins before you ever list your property. You need to define your ideal tenant in writing and stick to it. This isn't optional. It's your legal defense. California fair housing laws are strict. If you don't have objective, predefined criteria, any denial can be framed as discriminatory. You need a clear, consistent policy for income, credit score, rental history, and criminal background. For income, the 3x rent rule is standard. If your rent is $2,000, your applicant needs to show $6,000 in verifiable gross monthly income. Do not deviate from this. Do not make exceptions. Consistency is your shield. Now here's where it gets interesting. What about that applicant who offers to pay 6 months up front but only makes 2x the rent? Tempting, right? Don't fall for it. If your written criteria state 3x income, you deny them. Period. Making an exception for one person but not another is how you invite a discrimination lawsuit. I once knew a landlord who approved a charming applicant with a shaky income because they felt good about them. 6 months later, that charming applicant stopped paying rent, trashed the unit, and it took a year and $20,000 to evict them and repair the damage. Your feelings are not a screening criterion. Your written policy is. Once your criteria are set, you need a robust application form. This is your data collection tool, but it's also a minefield if you're not careful. You can ask for contact information, employment history, previous landlord details, and income verification. You can ask about pets, but you cannot ask about service animals. You can ask about criminal convictions, but there are limitations on how far back you can go and what types of convictions you can consider. Especially in cities like Los Angeles and San Francisco with ban-the-box ordinances that restrict inquiries about criminal history until a conditional offer is made. But wait, there's a catch. You absolutely cannot ask about protected characteristics. Race, religion, national origin, sex, gender identity, sexual orientation, marital status, familial status, disability, medical condition, genetic information, ancestry, source of income, with some exceptions for housing vouchers, or arbitrary characteristics like good looks. Even seemingly innocent questions can be problematic. Asking, "Are you married?" is a violation of familial status and marital status protections. Stick to what's directly relevant to their ability to pay rent and care for your property. I had a landlord client who asked, "What church do you attend?" on an application. They thought it was a friendly icebreaker. It became evidence in a fair housing complaint that cost them thousands, even though they claimed no discriminatory intent. Ignorance of the law is not a defense. This is the meat of your tenant screening process. You must run a credit check. A low credit score isn't an automatic disqualifier, but it tells a story about financial responsibility. Look for patterns of late payments, collections, and bankruptcies. A comprehensive background check is also non-negotiable. This isn't just about criminal history, it's about verifying their identity and looking for past evictions. California Tenant Background Check Services will provide this. For income verification, don't just take their word for it. Request pay stubs for the last 2 to 3 months, bank statements, or an employment verification letter directly from their employer. For self-employed individuals, tax returns are essential. Do the math. Ensure their gross income truly meets your 3x rent criteria. A landlord I know once accepted an applicant's verbal assurance of income. Turns out the applicant had just started a new job, and their income was based on a future salary, not current earnings. They were evicted 4 months later, leaving a trail of unpaid rent and property damage. Verify everything. Trust, but verify. Credit and background checks are quantitative. Reference checks are where you get qualitative insights. You need to contact previous landlords, not the current one. They might just want to get rid of a bad tenant. Go back at least 2 landlords. Ask specific open-ended questions. Did they pay rent on time? Is good, but can you describe their payment history? Is better. Would you rent to them again? Is a crucial question. Don't neglect the red flag questions. Ask about property maintenance. Did they keep the property clean and free of damage beyond normal wear and tear? Ask about neighbor relations. Were there any complaints from other tenants or neighbors? Be wary of landlords who give vague or overly positive answers without specifics. That can be a sign they're trying to offload a problem. One landlord told me a story about an applicant whose previous landlord couldn't recall any issues, but sounded strangely relieved to be talking about them. My client pressed further, asking about late payments. The previous landlord then admitted to 2 late payments in the last year, which violated my client's criteria. That single follow-up saved my client from a potentially problematic tenant. Once you've gathered all your information, compare each applicant against your predefined written criteria. This step is critical for legal compliance in California. Make your decision based solely on those objective factors. If an applicant meets all your criteria, you approve them. If they don't, you deny them. If you deny an applicant, you must provide an adverse action notice. This isn't just a courtesy, it's a legal requirement under the Fair Credit Reporting Act, FCRA, if you used a credit report or background check. The notice must include the name and contact information of the consumer reporting agency you used, and inform the applicant of their right to obtain a free copy of their report and dispute any inaccurate information. Document everything. Keep records of all applications, screening reports, and your decision-making process for at least 3 years. This documentation is your proof that you applied your criteria consistently and fairly. Failing to provide this notice or failing to document your reasons for denial can open you up to legal challenges. Don't leave yourself exposed. Recap. To summarize, protect your investment. First, write down your objective screening criteria. Before you advertise, making sure to include a consistent 3x rent income rule. Second, use a legally compliant application to gather necessary information, avoiding any questions about protected characteristics. Third, rigorously verify income. Run thorough credit and background checks, including a California tenant background check. Fourth, conduct diligent reference checks, asking open-ended questions and looking for specific red flags. Finally, make your approval or denial decisions based solely on your written criteria, and always provide a legally required adverse action notice for denials. Your diligence now saves you tens of thousands later. Powered by LeaseBase Intelligence.